5.
All right, good morning, the Senate Judiciary. It is Thursday, April 18th, and we're moving along on H 655, which is an act relating to qualifying offenses for stealing criminal history records. And Ben has left the room, and I don't know how to put Judge Zone on.
I
Judge
think if I
Zone
start,
knows how to put Judge Zone on.
I think I should be okay.
You're fine.
Okay, good.
I was worried about technical difficulties, but you solved it. All right. Any thoughts about this bill?
So good morning, Tom Zone, Chief Superior Judge. The bill is, as I listened to the testimony last week, as well as participated and listened to testimony in the House. In large part, the bill talks about some policy decisions by the legislature, so no comments on that. To the extent that the bill has requirements of the judiciary, we in the House, there were a number of areas that we thought would be problematic. We worked on those, and so this bill does reflect a number of changes that were made from the as introduced version to take into account the judiciary's concerns for implementation. So in terms of implementation, we think that we can work with this. Certainly, like any new statute, there will be questions. For instance, one of the provisions talks about the use of the sealed documents and access by the defendant, and it says the person's attorney. There's a lack of clarity as to whether that means it was the original attorney or the new attorney. And so those are the types of things that we'll have to look at going forward. But beyond that, there are the structure that is here is one that represents, again, a policy decision by the legislature that we will implement in accordance with the statute. There is a provision in Section 5 on page 38 that requires the Chief Superior Judge to consult and draft a report to the legislature for petitionless sealing. And if that's a report that the legislature would find helpful, I would certainly be willing to undertake that responsibility. And if there's any questions, I'd certainly be happy to address them.
Petitionless sealing has always been a thorn in my side. But that's just from an opinion, unless the law becomes no longer illegal, like marijuana possession of under 2 ounces. It seems like people who want to get their record expunged should take their own initiative to do it. That's been my view. So I don't know if others feel the same way about that section of the bill. I would tend to, when we get to markup, propose taking that out. So you wouldn't have to do a report.
If the legislature would like me to do the work, I will. If I don't have to do that task, I'm not going to argue with you.
Okay. Anything else, Judge?
No, nothing further today. Thank you very much. And thank you for the courtesy. Ben was kind enough to get me to the front because I had some other responsibilities today on teaching, and it worked out great. Thank you.
Okay. Our next witness then is Kim McManus, Associate General Counsel, Vermont Criminal Justice Council.
Good morning, Senator.
Good morning.
For the record, my name is Kim McManus. I'm with the Vermont Criminal Justice Council, and we appreciate the invitation to speak to House Bill 655. We had been asked to testify on the House side. Actually, we asked to testify on the House side as we requested to be added as an agency that had the ability to access sealed records. We have had a few occasions where an officer has been a defendant in a criminal case, and that case has either been sent to diversion or had a deferred sentence or was dismissed before adjudication. And we would still have a professional misconduct category A complaint that we were looking to move forward. But if any of those 3 things had occurred and the record had been expunged or sealed, we were unable to access that record and unable to use the evidence gathered during that investigation. So we very much appreciate that the House added us as an agency that would have the ability to access sealed records. And we do appreciate that the House raised concerns that there might be situations where we would want a criminal record of someone other than a subject officer, in that maybe the misconduct of the officer, some evidence might be in the affidavit of a criminal record of another person. And there was definitely concerns about that. I can tell this body, and we told the House Judiciary as well, that is the less likely scenario, but we appreciated that they wish to have guardrails up for us using any sealed record, and that's where the addition of creating rules and having those rules presented to LCAR and having those approved before we could have this access. And we appreciate the concerns around that, and we do not mind creating those rules. And we're happy to answer any questions that this body might have or any concerns that you have about the Criminal Justice Council accessing sealed records.
Any questions? Thank you.
All right, thank you so much. Have a nice day.
Okay. Jeffrey Wallen, there was a number of questions for you, Jeff, regarding how this would all work and what impact it would have on, like the tie.
Thank you, sir. That's my home state, Tennessee Volunteers, Smokey, their University of Tennessee mascot. So
Wow.
There's
I
always
thought it was the black dog from Maine.
Well, it can be that too. It's they are the eye of the beholder for sure. For the record, my name is Jeffrey Wallen. I'm the director of the Vermont Crime Information Center, which is part of the Department of Public Safety. And ultimately, Senator, to your point, hopefully I can answer any questions that the committee members may have, but I have a few things that I want to share up front that may help hopefully inform the discussion and prepare and pave the way for those questions or clarifications that I can provide. I think first thing that may be helpful for the committee is a sense of volume, what we're talking about. As the entity that maintains criminal history records, or rap sheets, if you'll prefer a more shorthand term for it, we process expungements and sealings issued by the court, which then affect those records. And in 2018, we processed 2,503 expungements and sealings. And for our perspective, there's no difference between the two as far as the workload. It's the same amount of workload to do one versus the other. In 2023, we processed 22,248. So that went from just over 2,500 in 2018 to just under or just over 22,000 in 2023. So we're seeing a significant increase over time. And it's also an order of magnitude more than it was a number of years ago when I first started there. So I thought that might be helpful just to get a sense of scale.
So, Senator Bowski.
Thank you. Do you have a sense, and maybe you don't know, if that significant increase was due to the automatic expungement and sealing of cannabis records because we ordered that those be, because it's no longer a crime?
We don't. That's a great question, and I want to be careful in my answer. Events like that certainly drive that, but because we really don't keep a lot of information once it's processed, we can't go back and give a real nuanced analysis. But when you see events like that, or for example, the expungement clinics that sometimes the state's attorneys will hold, logic just holds that those drive that volume, but I hesitate to attribute a percentage or any specific event to that increase over time.
But it is safe to say that at least some of that is sort of because of that and may dip back down once those are all done.
Certainly the first statement absolutely is driven by that. Whether it dips down or not will depend on other events as happens as well.
What is the practical effect if this bill were enacted? And somebody has a sealed record and they contact your department? what is the practical effect during the 10-year period where the record is available to some and not all? Does it make it more difficult or easier?
Well, I think, if I may, the way that it would work in the 10 years that's contemplated in the bill is the way that it works now, which makes it easy, which is to say that that information is only available to criminal justice agencies for criminal justice purposes, which is defined elsewhere in statute. So that information, the counts or counts that are sealed are flagged as such. And then if someone were to look at that criminal history record as an authorized entity, they would see that. That would not go back to members of the public doing a public query, nor would it go back to licensing, employment, or similar things unless, for example, as a criminal justice agency doing that hiring check, they would be authorized to see that. So it's essentially suppressed by its very nature. There is no ability in that criminal history record and in our data systems to flag when the event of a sealing occurred. So, for example, in the scenario contemplated here, after 10 years, we would have to have someone inform us it's been 10 years and then essentially delete it from the record. There would be no ability to maintain it in a way that would only be available to a very select group of individuals. So we'd have to look to someone else to maintain that record after 10 years.
So wouldn't it be simpler to do 3 and 7? 3 for misdemeanors and 7 for felonies? And just say it's closed unless you have a court order to open? I mean, it seems like what we have is we're developing a system, and all the evidence from Michigan is that basically after 3 years, misdemeanor, no more likely to commit one than the average person. After 7 years, and this is after everything's done, not after 7 years from the crime, but 7 years from release from probation, parole, whatever, and they're completely out of custody. After 7 years on a felony, they're no more likely than the average person to commit a crime. So I would think that it would be easier for everybody if it was, it could be 5 years for misdemeanors. I'd just throw out 3. But I know 7 years was the number in the Michigan study for felonies. So 3, 5, and get a court order after that to look at the records. It seems like that's a simpler system. So you don't do anything for the first 3 years. You don't have to do a thing. They're just as they are. If it's a felony, the first 7 years, you don't have to do anything. Then the record there's an application by the person, and if it's approved by the court and the judge, then you seal the record, takes court order to get it. So, Senator?
Yeah, I just wanted to clarify and make sure I understand your testimony. So you said the 10 years would be the same as it is now, and I'm taking you mean that's for sealing.
Yes,
because this bill would also take expungement and put that into the same regime, which is not the way we do it now. So expungement as such would cease to exist. So I feel like in this discussion, there's not nefarious intent on anybody's part, but it's to simplify. We keep acting as though what we're doing is moving a sealing regime to a slightly different sealing regime, but we would be getting rid of expungement where people have their record truly cleared, and we would be returning it to a system where their offenses remain with them, maybe for the rest of their life. It's just that fewer people have access to that record. So that's been my problem with this push all along, and I'm willing to go along with the move to make expungement and sealing one track, as long as that track is truly sealed in a way that's not going to impact their lives negatively. For instance, in the current bill, I believe, would let roadside stops access data about the sealed record. And in what way is it sealed if every time you're driving your car, it can potentially affect your life? So that's my 2 cents. If I've mischaracterized your testimony, let me know. But
no, Senator, I don't believe so, and I appreciate the clarification there. Really, if I may, and Senator Sears, to your point as well, if I may, Imitation being the most sincere form of flattery, I'll borrow a phrase that Judge Zone said. Certainly from my perspective as the repository director, I've got no opinion on some of these broader policy questions. I'm just trying to think through operationally how it could or could not work. And the criminal history record as we maintain it, the primary point of that is it's primarily used by law enforcement or criminal justice agencies. And if something's not available to those entities, we have to remove it from the record at that point. So there would have to be some other entity or mechanism for that data to be maintained. I do understand in conversation, one of the questions that has come up from time to time is research, for example. You know, once something is expunged in the current paradigm, it's as if it never happened, so it's gone, and so that can no longer be used, or some distillation of that record can no longer be used for research or analysis purposes, and that might be a conversation with the crime research group who serves as the statistical analysis center for DPS, where they may be able to speak to and provide information on how they could receive some redacted data that they could still use for research, but would not be of any use beyond just basic research.
Must have had a wealth of information in order to do the study that they did.
When I've talked to repository directors in other states, it is certainly is less common, although I wouldn't dare to give a percentage, but it is certainly less common for events to be completely struck as if they never happened, except in very unusual circumstances. But they maintain the data in some capacity or some distillation, so they can do, for example, the studies you're referring to, etc. So.
Just from a simplicity standpoint, though, right now, what the bill contemplates is sort of a two entry system. Like, you have to go in twice. You have to go in and sort of seal the record and then go in again and completely seal the record. And from a simplicity standpoint, wouldn't it be easier to just do one of those things?
Certainly from a operational perspective, touching a record once is better than touching it twice, if you'll allow the phrase. Exactly what you're doing may influence that. Exactly how in depth of a manipulation of the record you're having to do can speak to that. But broadly speaking, absolutely, the more times you have to interact with the record, it takes more staff time to do that. And that's exactly the reason why when we track the number of expungements and sealings that we process, we don't differentiate, because it's the same amount of work to do one action or the other at this point in all purposes. So for workload management and trying to project staffing levels and processing times, we simply track that as well.
So it's currently, if the record was expunged, there is no record for anybody to look at.
That's correct, Senator. It's as if it never happened.
If the person got a deferred sentence, was successful in the record expunged, your agency would have no record of that, nor would any law enforcement agency.
Certainly our agency would not. We would remove it.
But there may be officers in that department who originally arrested the individual.
I don't think we can delete memories.
Right, so there is that. I mean, you can't delete that, so that memory is there. They know that individual, you know.
But that person could move to another town and be largely protected.
Right, but it just, you can't erase that.
We can.
There would be people with knowledge of that. So at what point, is there any national data or any state data? At what point does the record become meaningless?
I don't have at my fingertips any studies that would speak to that. I'm sure there's some research out there, and I think, Senator, you mentioned some that talks about recidivism, et cetera. You know, when does a certain amount of clear water, if you'll allow the term, provide you insight? I will say that we have seen, and I don't have the exact details in front of me, but I can certainly provide it. Last year, there was a kidnapping case in upstate New York where the individual wrote hand wrote a ransom note for the minor that they had kidnapped, and
yes,
they were able to identify that based on a 24-year-old set of fingerprints from a DUI case out of New York. So while the length of time may diminish utility, I don't know that it ever gets completely to zero, quite frankly.
Yeah, I remember.
In that scenario.
Actually, that case, the guy's trial right now, I believe.
Coincidence, I think he was sentenced yesterday.
Oh,
Craig
okay.
Ross is the name of the.
Wow.
Yeah,
My nephew's name.
We're not talking about your nephew, are we?
He lives in New York.
Well, I was watching Albany News this morning and I heard something about, was it a sentence?
Well, and that is actually, that's the case we talk about when we train new recruits to the academy, that taking good prints is important because you never know when that might connect. And so to answer your question, Senator, it is fair to assume that the longer time goes by, the less utility the record may have, but I don't know that, again, that it ever gets to completely to zero. That's helpful.
Is there anything in the bill that worries you?
I think to reiterate, the concern is the time period, whether it's 10 years or whatever it might be. We have no ability to track that data. So we would have to have someone else inform us when that time has gone by to then re-engage with that record. And I'm not quite sure, quite frankly, who would do that or how that would be managed, but that would be outside of our ability to manage.
So if, let's say I have a record and I want that record expunged and it's 20 years old, or I want it sealed or whatever I want to do with it. I go to the state's attorney where that happened and apply, and the state attorney she says, okay, I don't have a problem with expunging your record, you've been 20 years. And she does the paperwork and everything. Doesn't that go to you then? And then you expunge the record? I mean,
in the current scenario,
yeah, what would change here that you wouldn't know that somebody had applied? That's what I don't know. I guess I'm not clear. Maybe Michelle, I need help. But I thought that you still had the same process where the person had to apply to get their record sealed
Under the new
under the
proposal?
scenario.
You do have to petition. I mean, there are some certain circumstances around where there's, that builds on the existing model. So like if the case is dismissed with prejudice or like certain things there where things are petition-less. But in general, for kind of.
Somebody needs to, that somewhere in the bill, somebody needs to let the director of, or Vermont Crime Information Center know that this has happened. They have no way of knowing that you
If
didn't,
somebody has filed filed a petition.
or that there's been approved. Or if it's,
I'm sorry, is it, so you don't get copies of the order?
we do, but it's in the current paradigm and regime, we do, but I just want to make sure that going forward, the expectation that would continue. We wouldn't be expected to somehow track this independently.
Let me look at it, but I think there's, when it talks about the effect, I don't think we changed that anything. I think that's all still the same in terms of when the order goes out, it goes out.
you
to
want
all
to
these
comment on that?
Yeah, I just thought,
Just
maybe
identify yourself for the record.
Tucker Jones with the Department of Public Safety. I think just to provide a little clarity on this. So this transitions to a single track sealing scheme, which is as it currently is how we seal the records. The real issue here, and the reason is what I was talking about last week, but also why we're back here today, is this concept of super sealing on page 25, which is that, and that's the
That's a
term.
totally different hearing.
That's a
That's
colloquial
completely
term.
different. So I just want to clarify is that in
I thought we were
76.
gonna take super sealing out.
I thought we were gonna move towards super sealing as the only
Right,
trial.
you guys, as far as I know, you guys haven't made a decision about, I didn't realize if you had made a decision and I haven't started a new draft, but just for clarification, what Jeff is talking about is that when an order is granted and the record is to be sealed, the court is directed to send a copy to all the agencies that have the record, including DCIC. That remains in the bill and that does not change. And so what Tucker's talking about is that law enforcement will continue to be able to see all those sealed records for 10 years. And what they're saying is that, well, then after that 10 years is triggered, because it's going to be a rolling, it's not going to be like annual on January 1st, February, it's going to be different depending on when the order was issued. They're not going to know when law enforcement can't still view those sealed records. Am I correct? That's what you're saying?
Yeah. I
So
think,
they don't know when, this is this is why I said the simpler thing is going back to whatever period of time the committee chooses for misdemeanors, whatever period of time the committee chooses for felonies. And it's after everything has been completed, you're off probation, you paid your restitution, everything you have to do. You can then apply to have your record sealed. Once it's sealed, then it's sealed, and you get a court order to look at the record. So it could be 20 years out before the person even considers sealing, and you're gonna make that, you, Michelle. The age 655 makes that person wait another 10 years. So grandma wants to take her grandchild on a school outing, and so she applies to get it sealed, and this is 20 years after her marijuana conviction, because she had 4 ounces, not 2. And poor grandma,
That's a lot of cannabis.
poor grandma can't take the grandchildren, and she has to explain to them grandma was bad.
Grandma was a dealer with 4 ounces.
And so, anyway, in my scenario, grandma's now waited 20 years, and you got another 10 years to go. She might die before you seal it. And I'm just saying that it's a simpler way, and if you have a need, if you wanna make it 15 years, I don't care. But for felonies, I really don't. It's just that at some point, the record is sealed, nobody has access except under court order. And poor grandma, could have waited. I mean, the case that I'm thinking of was 30 years later when she found out she couldn't take her grandchild. And it's crazy. Now, she did share her 4 ounces with other people, which became a dispensing. Not a sale, but dispensing, and that's where the problem. I will be totally frank about it.
You were.
That's
She
the
would
true
be
story.
eligible for sealing.
Yeah, but she'd have to wait, the record would still be there if she stopped on the side of the road. She didn't even care about sealing it until she wanted to take her grandchild on a tour. And that, and that's when this whole collateral consequence came up. So, we're talking 20 years after the fact. And then she's gotta wait another 10 years under this bill to get it, to have the record actually sealed. And I'm just suggesting that the school would still see that record, because they would have access.
Yeah.
I assume. So I'm just saying we could all agree, I don't care, but whatever, you say this is where it's stale, it doesn't mean anything anymore, and if I need to get a court order, I can do that. I don't have a problem with that. But I think that way there, you're worried about notice, I think you get your notice. That's why I said do away with super sealing, because you would be.
Right. So I think when you're saying get rid of super sealing is then cutting off, like what the bill was prior to in the House was that they could see it forever after it was sealed. And then what the House did with the super sealing is say, no, it stops at 10 years. I think what you're saying is you don't do, once it's sealed, go get a court order if you want to say.
Yes.
Okay, so it's not so much the super sealing that you have an issue with, I think it's the access after it's
Access
sealed.
after a certain period of time, pick a time.
Right.
And I like 3 and 7.
Well, I mean, yes, Senator.
Are records and information also sent to federal agencies?
Records are typically not sent to federal agencies, criminal history records, but they're made available through electronic means. So when we seal or expunge or manipulate or update a record at the state level, then that information, when someone requests it through federal channels, it's updated here in Vermont. So then that updated information, whether it's an updated disposition or it's been sealed or removed, et cetera, then that information is modified or no longer available at that level at that time. So we don't, it was for a long time, a criminal history record, and my apologies for jumping on point two, but I think I might know where you're going, so let me see if I can help. For a long time, there was a federal criminal history record and a state criminal history record, and those were maintained separately because the data systems didn't exist to maintain one record in multiple locations. Vermont, a number of years ago, moved to a process where the state maintains our own criminal history records, and there's just a pointer at the federal level that says, yes, Mr. Wallen has a criminal history record in Vermont, and then it comes through an ASSIST, and then it sends back along my 3 convictions for underwater basket weaving, my favorite fake crime. If those 3 are expunged, then that data no longer exists, and there's no longer a pointer that says Vermont has data on Mr. Wallen. So
For some reason, I thought all fingerprints were also shared with the FBI. I don't know why I thought that, but okay.
I kind of always thought that too.
well, we maintain fingerprint records here in Vermont in our systems. That information is maintained at the federal level as well to some capacity, but if something is expunged, then we remove it and it's removed from both the state
Well, I
and
don't
federal.
know that you need, I don't know that that is a record that I would necessarily want expunged. Because you have my fingerprints, because I was a state employee at one time in the Department of Corrections. I'm assuming somebody has them somewhere. And they're not expunged. I can't get those expunged. Why should a criminal get their fingerprints expunged?
Well, and Senator, to your point, 2 comments there. Actually, we don't maintain information on
Who
state
has
employees. Unless someone has
somewhere in the system, unless they got flooded out in Waterbury.
well, there wouldn't be a digital copy. I can't speak to that. There might not be
in 1970.
a file, physical file somewhere. We wouldn't maintain it, but someone might. But it wouldn't be anything.
Corrections.
They might. It wouldn't be anything we would ever be searching.
Okay. You wouldn't be able to.
Right. It would never come up on a search because we don't have it. But there might be.
I just assumed that. Well, when I was a foster parent, I had to go to the sheriff to get fingerprints. Are those still okay?
Those are not maintained. They're purged after 24 hours. So that we only maintain fingerprints. The vast majority of the ones we maintain are based on individuals who are convicted of qualifying offenses.
This might be a question for Michelle, but if federal agencies have any records and they're expunged in the state, how are they also expunged by these federal agencies? Because I don't think we can tell them what to do with information that they have, so.
Well, we would go in and remove that. So for example, we'll use myself and my fake crime of underwater basket weaving. If there's a state record of that that's expunged, and if there's any federal record of that as far as fingerprints or criminal history records, then we remove that as well. We do that electronically. We remove that from their system. We have a 2-way connection to that system and remove that as well. If there's any other mention of it in some records management or report system or something, to your point, we don't have insight into every single filing cabinet, that the feds may have, digital or physical. In the same way that we don't necessarily have insight into every, Senator, to your point, if you had a set of fingerprints that someone stuck in a human resources file back in the 70s, that may exist. We don't have access to it or any knowledge of it, but it may still physically be there.
Well, good to know.
That's a very common question. People come up to me, oh, you have my fingerprints because I volunteered at my kid's school. Unless you committed a crime while you were volunteering at your kid's school, we don't have that. No, we don't.
So the next question is about firearms. And Nick's, we spent a lot of time on background checks in this committee. So if the record is expunged or sealed, does that still disqualify from ownership of a firearm?
So, Senator, to your question, the expungement is an easier one to answer, which is right now in the current paradigm, an expungement is if it never happened. So we have to remove all record of that. And if that were the only event that we're disqualifying someone from receiving or purchasing a firearm, that event no longer exists. So therefore, that individual would be authorized to receive or purchase a firearm. Now, we don't have insight into every reason that someone may be disqualified to have a firearm. So I can't say that if someone only had one Vermont felony, that Vermont felony were expunged. that person might still be ineligible because they were dishonorably discharged from the military. We wouldn't know that.
This is another real case. A 65-year-old man lives in the Boston area. For years, hunted in Massachusetts, got a hunting license, and all of a sudden, they tell him he's disqualified because he has a record when he was 18 of breaking into an occupied dwelling. And he never got it expunged or did anything with it, and so he's been denied a hunting license. I would assume he's also denied being able to carry a firearm, but I don't know that for sure. But I know that he was disqualified. I sent an email and sent documents to the Attorney General's office looking to see if we could expunge that 45-year-old record. But I'm curious as to whether or not that hangs into the system. That's how Massachusetts must have found it, is in your system.
Well, it certainly could have. It certainly could have. We do find sometimes old records that had poor or no fingerprints, et cetera, that come to our attention, and we, again, keep those updated whenever possible. An expungement, again, if that's the only thing that was disqualifying someone.
Would sealing disqualify somebody from, having a firearm?
So in the current paradigm of a sealing being available to criminal justice agencies for criminal justice purposes, the FBI's NICS section is a criminal justice entity. So they would see that and they would have to comment on whether or not that sealing would disqualify someone. We don't make that determination at DCIC or in the state. So they would make
the one area where my little theory maybe doesn't work. Yes.
I'm sorry to interrupt, but my name is Rebecca Plummer. I am a lawyer at Vermont Legal Aid, and I've actually looked into this a little bit more deeply because we've had some clients who have wanted to get their firearm rights restored. And what I found, and it's very murky, but it doesn't contradict at all what Mr. Wallen is saying, is that the FBI's NIC list is really, I think, separate. And once it happens, it goes on to this list. And then they're not checking back, as far as I can tell, with the state or the federal criminal record system. It's in there, and if you want to get it off of there once your crime has been expunged, you have to go directly to them and petition, and it's a somewhat complicated process. So I don't think that they're coming back and forth about it. I think once it's on there, it's on there. And my understanding is that sealing doesn't mean anything to them. Expungement does, but you have to go through a process.
Well, and I want to, just to clarify, we have a disqualifying event, for example, a felony conviction on someone, and that's the only thing we remove that. There's no extra list where they keep additional information on that person. Now, that person may have been dishonorably discharged from the military, et cetera. We wouldn't have access to it, so they might still be disqualified. But if there's only one item, only one event, for example, a Vermont felony is the only item, the only thing that's disqualifying someone, and that is expunged or removed, there's nothing blocking that person at that point from moving forward. There sometimes is a view. The challenge is there isn't a list of everyone in the United States that can't have a gun. There's no single list like that exists. Whenever the FBI NICS section does an analysis, they look at multiple different data sources to see does this person show up anywhere. So there's not just one list that people are on or off. And that does mean, I think, to the point that was raised, that something may come off somewhere, but there may still be some other event that is tied or not tied to that.
This person, this grandpa, I'm on a grandpa today. He's a grandpa too. Even though he's successful in getting the record expunged from 45 years ago, he would, may not possess a firearm because he'd have to go to the next system to get that removed.
If that single criminal history event were the only thing that were disqualifying him,
I believe it is
an individual, and that was removed, and as if it was never happened, then that individual's rights should be restored without them having to do anything. However, for example, if that was considered, something like the individual was a user of illegal drugs, that could show up somewhere else in some other data.
Well, they were illegal back on the users.
And I hadn't been at VCIC very long when I first started, almost 14 years ago now. Still can't pull the bow tie like Max could, despite my best intentions.
Yeah.
So I stick with a straight tie. But I spoke to a gentleman who, I've never had an issue, and I'm trying to go buy a gun, and I was denied, and I pulled up the individual's name and date of birth, and I said, well, back in 1973, there's a felony possession of marijuana more than 1 pound. And he said, well, I don't remember that. I was smoking a lot of. So then I told him what court it was from, and I believe he went and got that expunged or something of that nature. But sometimes things do, from old days, do kind of cross back up.
Senator Biles.
In this sort of conversation about the gentleman Senator Sears is talking about, what does it interact differently if it's expunged versus super sealed versus this sort of other version of sealing that's not really sealed to anyone but the public?
Well, I think I'd have to really look at the language as it's contemplated here. I believe we would have to remove it after 10 years, and it would be up to the next section to determine should they reach out to the court or whoever maintains this super sealed record, and if they can get it, and if they can get it, what can they do with it?
Okay.
Because most of the language around who is eligible to receive a transfer of a firearm, purchase, own, et cetera, it comes from federal language, so we defer to them on that. I can't tell you anything that slows it down, is concerning to them, because they have a limited amount of time with which they can do an analysis. And so they are always looking to speed things up so that they can either, to the senator's point, if it turns out that's not an issue, they can green light that person and get them moving. They don't want to delay them any more than they have to. Or if there's a problem, they want to run it down and say, yes, you've got this issue, so we can't proceed it, and then they can challenge it or get it clarified if they need to.
So expungement is the only way that doesn't trigger some sort of digging further.
So both of my examples, this is not actually for the witness, but it's for others to think about. Both of my examples are long after 3 and 7 years. Mm-hmm. Before a person goes through the process, it's not just, oh God, it's been 7 years, I can get my record sealed. It's some event occurs that they realize that they're being disqualified, and it could be, in this guy's case, 40 years or more, and the grandma's case, 20 years or more after the event, and we're now asking 10 more years on top of that. And I'm not sure grandpa's gonna be able to hunt when he's 75. So, that's part of my concern here, with the way this is. It assumes everybody jumps in and says, okay, it's been 7 years, or whatever the time is, or 10 years, whatever the time is. Now we're gonna have that's automatic, and I'm gonna ask for sealing. I don't think people react that way. I think they wait. They usually don't do it until something happens and they realize that there's a collateral consequence to what happened way back when. And I tell you, more and more cases that I've actually been involved with, kids that I worked with who had adult records. Back when we first started the program, most of the kids were adult records, even though they were 16 and 17. And most of them never approached me until after 20, 25 years. And something happens, like those two examples. And then they say, what can I do about it? So anyway, that's just a side. Any more questions for Jeff? Our Director Whalen?
I'll answer to anything.
Thank you.
Thank you very much.
Appreciate you coming in. It's very helpful. Tucker, I know you and I have gone around and round about this issue for a number of years. I will remind you, we agree on many things.
Yeah, I was looking back at the Joint Justice recommendations from 2021. And obviously this has been going on much longer than that.
So just kind of a point of clarity and then some more specificity of specifically what we're asking. To your point about the time, 3 years to petition for misdemeanor, 7 years to petition for felony, that is in here. And that's current law, or that is contemplated in here. It's on page 16. So the idea would be you have a conviction, and then for misdemeanor, you have to wait 3 years to petition for sealing, or 7 years to petition for a felony, and that remains the case. The issue and the reason we're coming back is this concept of what would then happen 10 years later. And so right now on this is the super sealing concept. So right now on page 25, there's a provision, it's a new provision that says entities. So it's mostly the government entities listed there, including criminal justice agencies. Entities may access and use sealed records for a period of 10 years only in the following circumstances. So I think the concept there would be 10 years after the record is sealed. You have a sealing order that comes from the court. That's how it currently works now, and that's the triggering event for BCIC for their 22,000 sealing and expungement orders that they currently process. This introduces a new idea that there would be some automatic process that would be triggered after a period of 10 years. And in my conversations with Jeff, and also in my conversations with the person who manages the IT side of the CAD RMS, the computer aided dispatch and record management system, is that they do not currently have an automated process in place to date tag sealing orders as they come in, or to filter them other than how they're currently filtered, such that the public cannot see them, but criminal justice agencies can. So we haven't built the automated process that this bill introduced on March 15th. It doesn't currently exist. So that's the operational concern.
Yeah, I'm wondering, and this may actually be a question for Jeff, is there a technological barrier to building that process? Like, I understand that it doesn't currently exist, but what's to stop it from existing?
On the BCIC side, do you want to speak to that?
Certainly. I think that I don't want this answer to seem glib, but it's time and money. I mean, with technology, most things are done, but you're talking about a multi-year project, and I can't begin to fathom what it would cost to modify a system that is very durable by its nature, but that means it's somewhat simplistic because it has to be very reliable and very durable. So to develop something that would track that would be at least a multi-year project to develop that. And I would not want to quote any costs, but I know it would be greater than zero.
I believe that, thank you.
And Tucker, if I might be thinking of the wrong phase of this, but entities includes like Office of Professional Regulation, right?
Yeah, entities, and then it goes on to list them also, criminal justice agencies, and then there are new entities that are added to this.
Right, and honestly, this is the impulse that is slightly maddening to me, is that the initial discussion was to replace, in joint justice oversight, to replace the expungement sealing double track system with a single track, and it would be available to relatively few people. And then as the discussion has moved on, that list has broadened out to the point where everybody has access to the sealed record. So if I go to get a job or a license, or, my whole life is going to be dictated by something that under the system we have now in law, it would have been expunged and completely unavailable to anybody. So I've been frustrated that in this slow-moving negotiation over 4 or 5 years, public safety side, administration side, continues to argue for this vast, expansive regime, whether it's for 10 years or 20 years or forever. And I feel like this committee is constantly trying to create, yes, a more efficient single track system, but one that protects the people who were eligible for expungement, and we're now replacing that with sealing. So, I just don't see why OPR roadside stops, those sorts of things need to be included here, and why we can't have a judge direct access to the sealed record.
Senator Bowski and then Senator Morris.
Yeah, so my understanding under this bill is that if this bill were to pass as is, and people started to be able to seal their records, that the super sealing necessity wouldn't be needed for at least 10 years. And I'm assuming that the technological system could be built in a decade.
And the problem is, the idea would be that in July 1st, we would have to start date tagging these to know when that date would occur for these records, or whatever the effective date is, as they start coming in.
But if you had a system in, say, 5 years, it would be a one-time job to go back through and retroactively date tag those.
At what cost is the question. And then there's this broader question, separate from the operational implications, which, like, to your point, in theory, you can work all this out. You delay it for 2 years, spend however much money it costs to revamp it. It's all, in theory, doable. The follow-up question is, as a matter of public policy, is this the best way to cut the cake? And of course, policymakers, you're negotiating, you have to come up with some scheme that you want to please as many people as you can as part of it. But I was batting around the idea of, well, if it said 20 years, can we all just then move on, right? Something like that, or, pick your date, as you were saying. And from my perspective, from the policy side of it, the interest for the criminal justice agencies for some of these old records, it's very different than the interest for the predictive value for the employer or the landlord or whatever like that. In this case, I couldn't in good faith recommend, 20 years is okay, knowing that the Craig Ross fingerprint was related to a 1999 DUI. And if you look at that story or read that story, which I would encourage you to do, that was the difference in being able to identify this kidnapping suspect in that case and apprehend them in a matter of hours. And I wouldn't recommend that, as a matter of public policy, you introduce a scheme in which we're saying, well, we're not going to solve that case here in Vermont because we kind of put it all into one bill, and we were thinking about employers and we were thinking about landlords, and we're going to kind of lump in the criminal justice agencies there. There's a different interest at stake for some of those old records. I acknowledge that it's not as common for the cold case investigations that would want to rely on the incident narratives from 25 years ago to try to establish connections that they hadn't previously established. It doesn't happen that often, but sometimes when it does, it's very high impact. And the Craig Ross case is such a good example of that, because it's such a high impact that I couldn't recommend that you'd want to do something different here in Vermont for purposes of some policymaker negotiations reaching a year. All of this is to say, the problem, in my view, that we have, that this has taken so much time over the years, is because there's kind of broad agreement on the employer and landlord interest in the fact that the records lose their predictive value over these relatively short time periods, right? And that's fine. There's actually broad agreement on that. And
I'm sorry, what is the broad agreement?
That you have 3 years, 7 years for sealing, and the general public wouldn't have access to those records after that time. When a landlord requests a background check on a tenant, okay, sure, you don't think it has predictive value. The policy interest for the various government entities differs. You may find that, and OPR, I don't think has spoken yet on this concept of super sealing 10 years, they lose access. Maybe there's a time frame for them that, yeah, sure, of course, OPR, they don't have an interest in it, but criminal justice agencies would have some continued interest in it. And so you're trying to negotiate all of those things under one big umbrella. I think some other states have taken the simpler approach, and they have their government entity carve-outs essentially, and they say, all right, these are the times for purposes of employment, for purposes of housing, and it's straightforward. You're going to expand the system, include some of these felonies that haven't been included. That, it's not very controversial. There's actually kind of broad consensus on it. So anyway, I don't think it's anyone's fault. I think it's a complex thing that you're trying to do multiple things at once.
But it's my view. It's one thing to have access by detectives in the cold case bureau of the Vermont State Police. I don't know if that's what you call it. I think you call it the major crimes unit. But anyway, it's one thing for the major crimes unit to maybe get access. And maybe it should be simpler than a court order, and I don't know what that access would be. It's quite another thing for somebody who's making a traffic stop and it's a broken taillight and does a check and finds that this person has a 20-year-old conviction. What possible use is that?
And, this is the problem where now you're talking about the CAT RMS system, and you're talking about the background check that can be pulled via the CIC through dispatch, I assume. And so you want to limit access to certain people in certain circumstances, but it's not that they're a law enforcement criminal justice agency, it's that they're in a particular environment, like they're, it's in the cruiser, as opposed to them being able to send in that fingerprint to do the quick hit, in an emergency or in a major crime investigation. If you want to cut the cake that way, the question is, how do you limit access in that circumstance and not for other criminal justice purposes? And, we're obviously, I approach this as trying to come up with some sensible policy solution, but I don't think this super sealing provision that limits access and use after 10 years, it makes sense operationally and or from a policy perspective.
So again, I'll go back to my view is that the person, even if we don't need this, and I don't mind a longer period, but at some point you seal the record. And the only way you get access is the court. And that, if you want to make it longer, I can live with that. I don't need, I don't even, because as I said earlier, the average person doesn't even avail themselves of this until they realize it's hurting them, that record is out there. There is no magic to whatever years we put, in my point of view.
Yeah.
Everything can be 10 years.
Yeah.
And then you can apply, and then you go, and you get it. But, it's not like, unless we do the automatic sealing, that's where I have the problem with the automatic. I do believe people should have motivation to go do it, unless the crime no longer exists.
Senator, to your point, you're really pointing to the fact we make policy for the majority of situations, not the exceptions. And I think that, to your point, knowing that the vast majority of people at that 3 and 7 year mark have sort of.
But even if it's 10 and 15, whatever numbers we pick, they're just arbitrary, quite frankly.
I think they're pretty research informed, actually.
Well, actually, I'm not sure on the 3 years.
Okay.
7 years is research.
Okay.
I don't know who came up with 3 years.
And so the other concept here, and the House had some discussion of this, is, well, if you want to publicly use this, then maybe this provision of getting a court order to use it in a public forum makes sense. And there was some discussion of that. There was a few different drafts of this. And one of the concepts that we talked about is, well, if you have this 10-year period after it's sealed, then is what you really mean after that 10 years that you have to, if you want to use it publicly, then you have to go get a court order to do so. You have to unseal it. Is that really an idea that you have in mind? Take into account the fact that in order to
to unseal a record, you have to know that it exists and want to use it for some purpose that is public in some nature and some public forum and open court. And so there was some discussion of that in the House.
Senator Farouk Menashe.
So, and I think no matter what we do, simplicity should be a guide, because the reason we're still here is that the current system is not simple. It's multi-track and it's expensive on the expungement side to physically get rid of the records. And we've heard lots of testimony about that. What I would say is, in law now, expungement exists, and it's in effect a right that someone has. So it's a process that they're guaranteed in statute, they can go through it, and then once it happens, their record is gone. And so if I contemplate taking that right away from them, I feel like I need to guarantee that what's going to be in place is going to functionally be the same for them, that they're not going to be disadvantaged in ways that they were promised they wouldn't be disadvantaged under expungement. So back to the cutting the cake thing. I think right now, when it comes to expungable crimes, public safety and other entities have no cake. No cake. The cake is gone, right? There's nothing. What Senator Sears has offered by way of compromise right along is, here's some cake. You can have access to the records by going to a judge, and that's deemed not enough. And so we keep coming back demanding that everybody have it. And I just don't understand it, because if we dead end on this bill and it dies, we're gonna have expungement the way we have now, and those people's rights are protected. So I don't understand the continual unwillingness to recognize that what's being offered by way of judicial review and then allowing access to the records through a judge, that is something that doesn't exist now, and it's a huge boon to the public safety side to offer that. So I'll just leave it at that.
Yeah, and so to be clear, I'm not opposing this idea of if you're super sealing concept. Right now it just says access and use. And so there's no statutory definition of that access and use. So we're contemplating that what you mean by its plain language is that these entities, criminal justice agencies, wouldn't be able to access it or use it. So we're trying to figure out how we would implement that.
And to be clear, super sealing is not this committee's idea. That's an idea that
The last minute add-on by the House is like.
Yeah,
Right.
I don't support that idea, because I think it gets me to where I want to go. But again, 10 more years later.
See, I support that as the only path. Like,
You
there's
mean
no, like, the super
Making everything
sealing.
super sealed.
Yeah, like
Yes.
at 3 years you petition and your record is super sealed. At 7 years you petition, your record is super sealed. There's no bifurcated, like, it's kind of sealed for this
Right.
period of time. It's really sealed at this point. Like, that seems messy.
I agree.
Well, it's 13 years and 17 years.
Right, but
If you look at it the way it would actually function.
right, exactly. And I think operationally it's really difficult, but also just for a layperson understanding, if you tell me my record's sealed, I assume my record's sealed. I don't assume it's kind of sealed.
Yeah.
And then at some later date, really sealed.
And if you go to get a job in an apartment, it's not.
Senator Sheehan had a comment. I forgot.
Regarding a court
It
order,
was really
if
quiet.
law enforcement goes to get a court order for something that's super sealed, would they actually have to know what the specific offense is, or can they say any and all records related to this person because we're investigating such and such crime?
Well, and this is,
That was
none
my
of these,
intent.
none of these details have been worked out, right?
Well,
So,
what do you do currently for whatever you do with juveniles is what you should have access to in the adult system.
and I can look at the.
I don't know I know that, I dealt with juveniles for years. Some, as I said earlier, some were were adult charges, so those were access. But, I know there is an ability to get the juvenile records. I'm not gonna mention the exact name of the kid, but he was referred to me and we denied him. And I believe you got that record after he murdered several people. But we didn't want him, we didn't take him in our program. So, but we did have records and we knew who he was. And that was our fear, and then they put him in a foster home, and he ended up murdering several people. And I know they got those juvenile records. They may still have actually. So I wonder, I don't know what the process is for unsealing juvenile records. I had in mind a similar process, and I believe it's all the records you would have access to, maybe not medical. I don't know about that because that's HIPAA. Bob?
Thank you. So, Tucker, can you direct me to the page and section where it says that a law enforcement officer can have access to sealed records on the roadside stuff?
Well, right now, and this is current law, criminal justice agencies can use sealed records for criminal justice purposes. And this bill maintains that provision.
We're talking about the broken taillight where a law enforcement officer has access to sealed records. Is that it? Can you tell me where that is in here?
Well, criminal justice.
Probably, yeah, it's included within criminal justice purposes definition, so there's nothing specific on that point around for a traffic stop, but it's embedded in the larger definition of criminal justice purposes.
So my question is, so can a law enforcement officer on a broken taillight traffic stop gain access to sealed records via radio? Can he or can he not, Tucker, or she?
It's my understanding is like law enforcement officers, when they get a criminal record check done on an individual for, if they have a legitimate reason to do so, that criminal record check would include sealed criminal history information. That's correct.
So is a broken taillight information that you'd release that information on?
I don't know, operationally at what point law enforcement officer would request a criminal history check on an individual roadside. I don't know operationally if that would occur.
We're trying to simplify this. I'm just trying to get to the bottom of this as to my understanding. If you're going to do a background check, you need an incident report number. Is that correct, Jeff? To do a 29C, or you have to have an incident report number to do this.
Yeah, a case number incident.
It's not generally produced through a broken taillight motor vehicle stop. Unless there's a series of charges that goes along after that. I just can't see a law enforcement officer asking for this roadside. That's all my experience I've had on the road. If someone's charged, you go back and do the proper paperwork, you do your 29C, you have the incident report number, whatever else. I can see the background check going through for court purposes at that particular point in time. But for someone to actually pull someone over for as used a broken taillight, I just can't see them requesting to open up a sealed record for that purpose. Roadside.
I mean.
But it is allowable.
But to your point, operationally, I don't know if when that occurs, a roadside. I don't know, and I could find out.
Can imagine.
In a general circumstance.
What if it's somebody from Springfield, Massachusetts, Holyoke, Massachusetts, driving in Bennington?
What town was Ash from?
Huh?
What town was Tim Ash from?
We could use that as an example, but Holyoke has been identified as where most of the drugs come from in the Bennington and surrounding areas. I'm just suggesting if they stop somebody there from Holyoke, Massachusetts, I would think it would be a signal to get more information of who we're dealing with here. I would think any police officer would.
And I take Bob's point, it may not be common to do it that way, but to Tanya's point, if it's allowable, that's a problematic thing.
I think we've got we're back to as Zucker noted earlier, we're back to the basic problem in terms of a disagreement about particularly how we deal with this. I will say that I'm not a fan of the super sealing section. I think it's unrealistic. I think there's an easier way to get there. But anyway, Senator Sheen.
When you mentioned 29C III, brought back a flood of memories, but I think
Hope they
that
weren't nightmares.
from, no, not, most of them, no. But, from what I can recall, it's, you know, if it's just a civil violation, just a taillight out or going over the speed limit, you're not punching a case for that. But if you have reasonable suspicion and you're investigating something that could be criminal and you punch the case for it, then you run the 29C III, as you know. But yeah, so if you're investigating that crime or you have reasonable suspicion to start a case number, or you suspect a DUI and you pull them over for that and you start a case number, then you can run the background check by asking dispatch to do that. So, yeah.
Have you ever run one? I've never run one in my 30+ years roadside.
Yeah, I mean, any DUI, anything that is beyond just the initial stop. So if it's, for a traffic stop for speeding, no, of course not. Just running through Spillman or I guess Valport now. But if it's a speeding stop and you end up, seizing 100 bags of heroin, you're gonna punch a case and run the 29C III on the roadside. And then you get that paperwork when you get back to the department.
Tell me what you're doing when you go back to the cruiser and sit there for 15 minutes making me wait? What are you doing? Are you just making me wait, or are you?
In defense of that, the donuts are bigger now than they used to be back when you. But, a lot of times dispatch may be busy. They have multiple units out there besides just yourself. And your 15 minutes sometimes may feel like 50 minutes when actually it's probably 5 or 6 minutes.
Okay.
But, believe me, we don't want to be there any longer than what you want to be there.
Well, this was in Wallingford. It was the sheriff. And I wanted to tell him I knew John Bloomer, but I didn't get a chance. And luckily they didn't give me a ticket, but it was about 50. I didn't time it, so you may be right. It was like 5. But what do you do back in?
Well, we're just trying to get into the sealed records. So make sure.
That's what I'm saying.
Yeah.
Well, but what are you doing back there?
Watching YouTube videos.
Huh?
Basically, you're running your 28s and 27s, your license check, your motor vehicle check.
Okay, making sure I have insurance, et cetera.
Well, I'll ask for your license registration.
Yeah, you take
proof of
all
insurance
that.
right off
You've
the bat.
taken that.
Yes, and I'm going back to verify that it's still
Vermont
valid.
is much better than Boone County, Kentucky.
I've never been stopped in Boone County, Kentucky.
Well, they take all of your stuff, and then they get enough people, and then they do a convoy to the local sheriff's office, like Andy Griffith, It feels like that, and then you have the judge, he acts as the judge, and he says, you can get $200 bail if you have that in cash. And you are allowed to go out to your car and get your cash. And then eventually, you don't have to appear in court, but then they send you a check for the remainder of your fine.
Well, roadside stops in Vermont, we try to expedite that as quickly as
But
possible.
I'm
Those are
just
one of the
saying,
most dangerous
better
things
than
that you
Boone
do
County.
between traffic, people in the cars or whatever else. So we don't want to hold you there any longer than you have to. So.
Okay, well, that's good to know. I just wondered what you all do. Tucker, thank you very much.
Thank you.
Appreciate it. And, we'll continue our work on this. I've got the sealing of the records and how Human Services deals with it.
Yeah, that's just the one. I didn't do it on it. It's just proceedings and stuff. That's the one once the records just deal. And then also the committee members, I emailed you the definition of criminal justice purposes that's currently in statute.
Yeah, sheriff, the police chief, the state's attorney, the attorney general, and director of Vermont Crime Information Center. Designated clinical staff are allowed. It's quite lengthy. It is Title 33, Chapter 5119, sealing of records in the juvenile.
Senator, here's the study, the University of Michigan study you were talking about. Is that the one that the Harvard Law Review looked at a couple of years ago that looked at, it was sort of an empirical study that looked at the benefits and the theoretical detriments? Because I'm looking at one now and it says 2 and 5 years, but it says it's the University of Michigan Law School, so I'm confused.
I thought it was Michigan. But,
Okay.
Rebecca, is there?
I'm just trying to find your
Then we're
study.
gonna take a break.
Thank you. Good morning.
Good morning.
Good morning, Chair and Senators. Thank you for this opportunity to share Vermont Legal Aid's thoughts on H655. My name is Rebecca Plummer. I'm a lawyer at Vermont Legal Aid, and I've been a civil legal services lawyer for about 25 years, and I've worked in a lot of different areas of legal services in Vermont and Boston. And I'm currently the director of Vermont Legal Aid's Medical Legal Partnership Project, where we provide legal services that address a wide variety of health-harming legal needs. And we have a couple different kinds of partnerships. But until last year, we had a partnership with several medication-assisted treatment clinics around the state working with people with substance use disorder. And through that partnership, we worked with a lot of people who had criminal records from a time when their addiction dominated their lives. And now in treatment, some of them for several years, they had completed their sentences and they were really desperate to move forward, to support their families and themselves, and to find decent paying jobs and safe housing and education and training. And through this project, we helped a lot of people obtain expungement and sealing orders, and they made a really big difference in people's lives. We continue to do criminal record clearance work, but because of limited resources, we're not able to help a lot of the people who ask for help. But when we do, we sometimes have to convey to people the news that their record is not eligible, or it's not eligible yet. And for some people, it's a permanent barrier to their ability to reintegrate and support their families. So we're really appreciative of the efforts to expand the list of qualifying crimes in H655, particularly the focus on adding crimes that are often related to addiction. And we appreciate the reduction of the time limit for sealing misdemeanors and the move towards automatic clearance. But while we appreciate these aspects, we really want to express some concerns about the bill. First, we don't agree that expungement should be eliminated. We view expungement as a critical tool to address the over-criminalization of Vermonters that was really pervasive for several decades, and a recognition that people can move forward from the mistakes that they made in the past. And we understand that switching to only sealing might create some ease for the agencies that hold these records, but because Vermont law and policy is what created the number of criminal cases and numerous collateral consequences that flow from them, we believe that Vermont should continue to have the protections that have been in place through expungement, especially regarding criminal records that are not expected to result in recidivism. And the burden on the courts and law enforcement really has to be balanced with the significant value of a clean slate for eligible Vermonters. And I want to say that we also oppose the elimination of expungement in this bill because expungement is a critical tool to address racial inequity in our criminal justice system. In Vermont, a disproportionate number of Black and Indigenous people have contact with the criminal legal system, studies have shown. And as we know, the implicit bias that we all have, and law enforcement is no exception, plays a large role in this disproportionate effect. And unfortunately, it's reasonable, therefore, to expect that law enforcement and other criminal justice agencies will disproportionately use sealed records against people of color. And indeed, it would be illogical to expect otherwise. So limiting this access is the best way to prevent the racially inequitable use of the records. And that goes to the discussion that we were having about, that the committee was having about the traffic stops. If it's possible to do, and perhaps a law enforcement officer's choice whether to take that step to look into it could be influenced by as you say, whether the person is from Holyoke, Massachusetts, or perhaps additionally, the color of their skin, without them even realizing it. We are also deeply concerned, like the Defender General's Office, about the significant expansion of access to sealed records. Who has access and for what purposes? And so wide access to sealed records by criminal justice agencies, in line with what I just mentioned, is extremely likely to lead to disparate treatment of Vermonters of color. The more access there is, the more likelihood of disproportionate effect. Disparate treatment and disproportionate effect. In addition, the expansion of access to all sealed records, and not just the carefully thought out crimes that have been carefully determined in the past to merit a graduated sentencing, for all kinds of criminal law purposes, for investigations, prosecutions, trials, and sentencing, really defeats one of the primary purposes of our current sealing and expungement law, to give an opportunity for a clean slate. The specific extension of access to the Office of Professional Regulation directly undermines another of the primary purposes of expungement and sealing, as well as the collateral consequences law that was passed in 2016 to help people move on and get jobs. And as the Defender General's Office testified last week, we can expect that the requests for access to these records will continue to multiply. And with more people and entities having access comes a greater likelihood that sealed information will be leaked and cause collateral damage to the people involved. So I testified in House Judiciary soon before this bill passed out of the House. At that time, I expressed these concerns and urged the imposition of a time limit on the proposed expanded access to sealed records. And soon after that, we, like the Defender General, were among those who said we wouldn't oppose the bill if it had a time limit on that access, which is what has now been referred to as super sealing. So I would say that, like the Defender General, we would be strongly opposed to this bill if super sealing were removed, unless, as has been discussed this morning, that higher level of sealing happens at the time of sealing. And I understand the chair's point that a lot of people don't request sealing until some precipitating event later in their lives. And I certainly worked with people for whom that was the case, where they wanted to take their kid on a field trip, or they wanted to teach their kid or their grandkid how to hunt. And they decided to take action on this. And that is certainly true. But there are also, I think, a lot of people who, at least people with substance use disorder in treatment, who in their 20s and 30s, they have a family, and they are desperately counting the days until they can seal or expunge their criminal record in order to get a decent place to live for their family, or a job that's pays more than minimum wage. And so I think 10 years is actually a long time. And in the case of misdemeanors, if, for example, we said, the bill said everything happens at 10 or 15 years, that's a big step backwards from what people have now with expungement and the current law of 5 years. So I think those years do make a big difference, what you choose to have as the starting point for any form of sealing, even if that sealing is a stronger term than what's being talked about here. And we would absolutely be in favor of a single tier system like that, where it just happened sooner and access was only by court order. I think that would bring questions about who then would have the right to petition the court for access.
Well, the juvenile sealing statute provides some guidance that you have access to your own, it's a long and complex, but it provides something that could be a model. It's Title 33, Chapter 51, 5119, sealing of records in juvenile cases. That provides for, on a confidential motion, that the basic is confidential motion of the law enforcement officer or prosecuting attorney, the court may permit the department or agency to inspect its own files and records if the court finds extraordinary circumstances in which the state's interest in public safety clearly overweighs the purpose of the juvenile sealing law and the privacy rights. And then it goes on to further allow checks into other records. But again, the standard is that the criminal justice purpose outweighs the purpose of juvenile sealing law.
And so that would also, it sounds like, be specifically for criminal justice purposes and not some of the other access that is envisioned by the.
Yeah, it's only criminal justice. There is a provision for allowing the person to unseal their own record if they had some reason to. I don't know what that might be.
Mr. Rashim has brought up some instances where someone may feel after the fact that they were treated unfairly and they want to open it to.
Yeah, there is provisions there. I just was looking at the criminal justice purpose.
Well, so just in conclusion, we believe that the Vermont law should reflect the evidence that has been discussed about likelihood of recidivism and usefulness of records, and should discontinue access or not permit it in the first place after these time periods have elapsed, if people seek that. And we are also, we believe that the legislature should not erode the protections that are provided by previous legislatures regarding expungement and sealing and all of the collateral consequences.
So you're basically saying that the current law should stand unless this improves things.
Yes, yes.
Which is a pretty good guide for legislating in general.
Well, I suppose, but it's probably the Hippocratic Oath in legislative parlance. Senator Rashim.
Thank you. I think, I mean, when we were doing expungement and I was in the House, I was a strong supporter of it. And I mean, I support the super sealing aspect of this, but in thinking about it further, I just generally hold concern about the idea of the complete obliteration of a government record that documents steps taken to curtail somebody's liberty, and just the state then afterwards saying that never happened, we have no idea what you're talking about. And so that's a concern of mine, but I also still want to make sure that we're taking steps to reduce and, as much as we can, realistically eliminate the collateral consequences, you know, after a number of years of somebody having committed an offense that they've moved on from. So I guess that's just a general comment.
Senator Bowles.
Thank you. I don't know if legal aid has this data or keeps this data, or if you can point me to where I might find it. But what I'm wondering, you know, having done some research in the rates of crime that occurs after records are sealed, which is actually lower than the general public, I'm wondering if there's any connection or looking at the rates of crime that reduces if someone has access to education or has access to higher wages or does my question make sense? I feel like I'm sort of.
It does. We certainly don't have that sort of research capacity, but I think that and I can look into this certainly and get back to you. Okay. I think that there is research out there about the beneficial effects of the greater access to education and jobs. And
one of the findings that I read in Michigan, I'm not sure which study, but the findings were that people's income rose by 25%.
Mhm.
Which is a huge percentage in terms of income, if you think about 25%. And so once you raise your income by 25%, I think you're less likely to need to shoplift or
Right.
whatever.
Well, and that's sort of what I'm trying to get at, is some sort of empirical evidence for what I believe to be true. And that is that the public safety interest served in truly sealing these records is actually much greater than not, because it gives people access to higher income and education and work and living opportunities that actually further lower.
This was before our housing crisis.
Yes.
Nationwide. I mean, it's not, we think, oh my God, the housing crisis is just in Vermont, but it's not, it's everywhere. And so, you know, that is a other factor for people that ask me. But I appreciate your testimony.
Thank you very much. Thank you all.
Thank you very much. So we're gonna take a break until 10 of.